Here we will focus on the general characteristics of wills only. In the next episode we will see what types of wills are accepted by the Italian law. As already mentioned, the topic is particularly complex and articulated. In order not to make the speech excessively technical and inaccessible to most spectators, we will limit our examination only to the main aspects. All this always using a common language of immediate understanding. And now, let's see a clip together.
It is now necessary to address the problem of the will. This is an extremely complex and articulated topic, which it will not be possible to examine here, in all its specifications and characteristics. However, we will try to clarify the main points concerning it.
The will is the only instrument, according to Italian law, with which a person can dispose of his or her assets, for the time following his or her death. Precisely, due to the fact that this deed is intended to be enforced only after the death of the person who drafted it, that is to say, when the testator is no longer in a position to correct or modify it, the law guarantees particular protection to the statements contained in this document.
The will has, as its main function, that of allowing the decuius to attribute his or her own estate, or some specific assets that compose it, to one or more persons, who, in this way, are entitled to become heirs or legatees.
However, the will may also contain provisions not purely aimed at the attribution of the testator's assets, such as the recognition of a natural child, the designation of a guardian, the appointment of a curator or an executor of the will, the rehabilitation of the disqualified heir, an out-of-court confession, or acknowledgement of debt.
The will, in order to be valid, in addition to having to comply with a set of rules and regulation established by the code and relating to its form and contents, must be free and spontaneous. That is to say, that it must be the expression of the free will of the testator, not coerced, influenced or directed by third parties.
Certain and definitive in its contents. This implies that, from the reading of its text, it must be clear, in an unequivocal way, what the actual intentions of the testator are, with respect to the destination of his assets, for the time following his death.
Complete. Namely, suitable for regulating all the property ownerships of the decuius, following the opening of the succession.
Always, until the death of the testator, the will is modifiable or revocable by the latter.
In the first case, that is to say, in that of the modification of the will, the new testamentary dispositions will take the place of the previous ones, substituting them.
On the other hand, if a mere revocation occur, that happens when the testator just disowns the validity of the will, already compiled. The said will shall be then considered forfeited, so that, upon the testator's death, an intestate succession will be opened.
However, even in the event of revocation or modification of the will, the statements already formulated, and relating to the recognition of a natural child, the rehabilitation of the heir, a confession, or an acknowledgement of debt, will remain anyhow effective and valid.
The Italian law, while admitting that the will may contain conditions and terms, as well as majoraces, that are burdens or encumbrances to be borne by the beneficiary, anyhow establishes special rules in this regard, which limit the usability and effectiveness of such instruments.
But who can dispose by will? According to the Italian law, to draft a valid will, the testator must, at the moment in which the last wills are expressed, have full legal capacity to dispose, and be in no mental disorder or drunkenness condition. To have the legal capacity to dispose, it is necessary to be of age, and not subject to interdiction.
To be free from any mental disorder or drunkenness condition, it is necessary not be affected by any condition of psychic illness, even if temporary or transitory, which might affect the ability to understand the meaning and value of the acts that are being performed.
The will is a legal instrument full of complexity and difficult to draw up correctly for those who are not experts in the field. When the inheritance axis is composed of a few assets of simple management, and those who are indicated as heirs are in agreement and do not have conflictual situation among them, so that it can be foreseen that at the opening of the succession there will be no fights between them, the testator may venture to draw up a will himself. Also in this case, it is good that he or she reads up well on how such a deed shall be composed, to avoid making it null or void due to the failure to comply with mandatory laws. Conversely, however, when the assets that make up the estates are many, or of great value, or consist of assets of complex management, such as complex financial instruments or sharing companies, or if there are significant inheritance liabilities, or if there are disagreements between those who will be the heirs. It is always advisable to request the assistance of an expert to carry out the necessary asset planning and to draw up the will itself. Even when formulating one's testamentary disposition by oneself, there are some particularly delicate aspects which it is always good to keep in mind. A very delicate first question arises when revoking a will if there are other wills prior to the one the testator wants to revoke. In this case, it is always good to specify whether, with the revocation, you intend to cancel all the previous wills, thus creating the condition for an intestate succession, or if only the last will shall be revoked in order to restore effectiveness to the previous will. Another aspect to keep in mind is the psychophysical condition of the testator. If for any reason his or her condition could raise any doubts about him or her being in a state of mental disorder at the time in which the will is drawn up, and the inheritance is of value and conflicts between the heirs are foreseeable, it is appropriate to pre-establish the evidence that the testator is fully capable of understanding and making decision about his or her will through the appropriate certification by a specialist doctor issued immediately before the drafting of the will. Also, this episode ends here. Thank you for joining us. In the next episode, we will still talk about the will, but we will deal with the question of which type of wills are provided for by the Italian law and what are the consequences of not using one of these types. I'm waiting for you next Monday, always at 5 p.m. Rome time, always in live streaming on our YouTube channel. Don't miss it. Remember to subscribe to our YouTube channel or to follow our Facebook or LinkedIn page or our Twitter account to be informed of new videos and to be able to review past ones. See you next Monday and thank you for joining us.